for the India community, helping and giving the resources. In the part of the series of trying to educate the community with the legal issues, we started last time talking more on the immigration issues. And this time we thought that it's great thing for the community to know and understand more about the wills and trust. As we know that we work so hard to make money, we also have to learn how to be saving those things and helping us and the future generations. So I thought that I want to introduce my good friend Hashi Richards here. Hashi Richards established Richards Legal LLC based in Orlando in 2015, and her practice areas include estate planning and trademarks. Prior to opening her own firm, Hashi worked for over 10 years in private banking, estate administration, and for a large law firm representing banks and mortgage servicers. She graduated from the University of Miami School of Law and School of Business, earning a dual JD and MBA degree. She's a former adjunct professor at Kaplan University, where she taught courses in landlord tenant law, administrative law, and legal ethics. She is currently an adjunct professor at Valencia College, where she teaches business law and real estate. In her free time, she trains for marathons and just ran the Chicago Marathon. She also loves to cook and spend time with her family. And something she didn't put, I know that she's a great, great, great mom and a great friend for a lot of us. Continue to inspire community, and let's welcome Hashi.
Thank you so much, Madhu. That was an amazing introduction. Now, I'm embarrassed about that, but thank you so much. And thank you, Srini, for having me today. And welcome, everyone. I appreciate you spending your Sunday morning with me. I think that you'll find this very valuable. So this presentation really applies to everybody. If you're a parent, if you're a grandparent, or even if you have young kids or adult children, I think you'll find something valuable in this presentation. What I would like to do is run through the presentation, and at the end, we'll have some time for questions. So you can post the questions in the chat, or if Srini prefers, you can unmute at the end and raise your hand and ask your question that way. Also, I shared with Srini a webinar book. And so if I don't know, Srini, if you're able to share it in the chat, but people can print it, or you can open it up on your phone and sort of follow along while we're going. Okay, can everyone, you can see my screen okay?
Yes.
Yes. Perfect. Okay, so the presentation is titled Estate Planning is for Everyone. And again, so glad that you're here with me today. So, the best way now in today's day and age is to turn off your phone, which you have to look at it for the workbook, but other than that, no Facebook, anything like that. And really, devote this time for yourself and for your family. So in the workbook, there's some questions along the way that we're going to sort of match up with the presentation. So you can follow along. And even if you don't write down the answers, you can think about them for your family and how it applies to you. And I urge you to think about people that you love. For myself, it's my parents, my husband, and my children, and also some extended family members and my friends. So you can keep those people in your mind while we're going through the webinar. Oftentimes when I meet with clients, they always express certain doubts. And typical doubts that I hear is that once they meet with me and plan their estate, somehow death will be imminent. That's number one. Number two, some people think the process takes a long time, that they don't have the time, it's too much paperwork. Oh, I don't know, how to do the process. And so it just makes them stop. And then the final reason is some people say, one second, I'm going to mute. I think some people are not muted. Hold on one second.
I think if we can all mute, it will be helpful.
Yeah. If I mute all, that means I'll mute myself and other people, and I don't want to do that. So thank you so much. Okay. And then the final reason, which I hear a lot, is people say, well, I'm only in my 30s. I'm only in my 20s. I'm only in my 40s, 50s. I don't need an estate plan, right? Or they say, I don't have enough money. Estate planning is for people that have millions of dollars. The good news really is that none of those are true, right? In all my years of doing this, knock on wood, nobody has ever passed away the next day after I've met with the family and done their estate planning. It's not imminent. You also really truly owe it to your loved ones to have an estate plan, because there's so much nonsense and headaches to deal with if it's not properly planned, and it's not fair, to your surviving spouse or to your children. It's really a gift that you can give them. And quite frankly, estate planning, even though it may sound complicated and has some status to it, it really is not directly tied to your age, how much money you have, your parental status, your marital status. Everybody needs an estate plan. Just to reiterate, and I have to keep honing in on this point, it's really not about you, because you'll be gone, right? It's really about the people that you leave behind, the people that you love the most. And just personally speaking, when I first graduated from law school, I worked on the back end. So I was dealing with estates that have already been, the person's already died, and I'm dealing with the things that they left behind. And you can tell if it's organized or not organized. And the bickering sometimes among the family members when things weren't done properly is not something that I wish upon any family, even my own or any of your families. Today, you're going to learn a few things. You're going to learn, if you have minor children, or if you have children that have minor children, how they can name guardians for their children. You're also going to learn how to avoid probate court, some different type of options that you can pick when you're estate planning. Also, you're going to learn the difference between a will and a trust, and then how best to protect any inheritance that you may leave for your children. We're also going to go over, how to start your own estate plan, what is involved in that, and just a general rough idea of the costs involved. Here's a little information about me. I do estate planning. I also do probate and personal injury via referral, meaning that if if you're injured in an accident or anything like that, I don't directly handle the case myself, but I have quite a referral network. So you can always call my office and I can link you with someone excellent to handle that portion. So people say sometimes, I don't have an estate plan, but really we all do, even if you haven't met with an attorney, even if you haven't drafted a will. And it is the state that you live in. So everyone here is maybe Florida residents, hopefully. And I'm only licensed to do Florida estate plans. And so if you don't have a written will, guess what? The state has one for you. And it may be one that you don't like. You can Google it if you want. It's called intestate succession, meaning if you die tomorrow with no plan, they will go to their laws, the statutes, and look up who will inherit your property. Whether you like it that way or not, they will be entitled to it. So really, that's the default plan for you. On this slide, and feel free to take a picture of these. This is some of the goals of estate planning, right? To be able to give to who you want, the way you want, and when you want to. A lot of people want to avoid probate court. There's also one aspect of estate planning which applies while you're alive, and that's called, I call them ancillary documents, and those are preparing for incapacity, whether it's your health or financial incapacity. And these documents apply while you're alive, right? In case you're unable to handle your own affairs, in case you're unable to make a decision about your health, who will step into your shoes to do those things? And a lot of people have the misconception that your spouse automatically has that right in Florida, and they do not. You need to have these documents in place. Otherwise, even your spouse may not be able to make decisions for you. One big thing that I often hear from my clients is, you know, if you have adult children, or even if you have young children, and you want to make sure that whoever that they marry don't take their assets and they keep it in the family. You can also set up your trust and estate plan to avoid any of those issues and protect assets from creditors or divorce and things like that. So this is a great slide if you want to take a screenshot of that.
So, Hashi,
Yes.
just for a small question. So, what you are saying is, if you don't write any of, you don't plan any estate planning, so then it is not like a default spouse is going to take care of the things. But you are saying that it's not. Whether even if you are living due to the health conditions, if you are not able to make decisions, or if you are any other incidents, accidents or something like that happen, so if you are not able to take decisions, then spouse is not the one to take care of the decision.
Correct, Srini. Especially when you're alive, I've seen situations where, because if you imagine, sometimes people are estranged from their spouses, correct? Or they're not living with them, or whatever the situation may be, but they're still legally married. So if they go by that default and call the spouse, sometimes I've seen it before, they will Google and see, are you married, or ask people. And if they call that spouse and you're not even together with that spouse, that's the last person you want to make the decision for you.
Mm-hmm.
And so that to avoid that, you have to have these documents while you're alive. And maybe there's some cases that some people, hospital people may just not follow that, but legally and technically, that is the way to do it. That way, your spouse or whoever you name, if you're not married, you can name another adult over 18. They are going to plan how you wanted to plan. So for example, I always use this example in my consults, which is one that many people can understand. If you're having a surgery and something goes awry during that surgery, and then the doctor comes out and says, okay, I have to make a decision A or decision B. Who is here ready to make that decision on behalf of the patient? If everyone in the room says me, who are they going to ask? It's a nightmare. So it's better to have these documents in place while you're alive. And what I was referring to about when you pass, again, this estranged spouse situation, you may not want that spouse to inherit, or whatever the case may be. They will go to the statutes and start in the order. So that's why it's really important to have these.
Got it. Thank you. Thank you. Go ahead.
You're welcome. That's a great question. Thank you, Srini. Okay, so downsides to dying intestate. This is a word that I was referring to. This is when you die without a will. Okay, they distribute according to state law. And the other major thing that a lot of clients get afraid of, including myself, I have an 11-year-old son, is that whatever the state statute says, when your children, if you have children that are minors when you pass away, with the minute they turn 18, so before 18 years old, the money is held in guardianship. They're not allowed to touch it. So you have a guardian, that's appointed by the state because you haven't planned your documents. That guardian will be in charge of that money. The day they turn 18 years old, they get a check mailed to them. It could be for $100,000 or $1 million. I don't know about you, but I do not want my son to get $1 million on his 18th birthday. When I was 18, that would not have been a wise decision for myself either. Okay. And the judge will decide who's in control. And the scary thing for a lot of parents is the judge will also decide who raises your minor children. Because if you don't have a will and you haven't named guardians in your will, and we're going to talk about that a little bit later, the judge will have a hearing, and people that want to raise your children will come forward and say, Hashi said that I would raise her son. No, then someone else will come and say, no, she told me. She told me. And the judge will listen to everyone's story and say, you know what? I pick this person. She sounds like the most qualified. Is that what I would have wanted? No one knows because I didn't have it written. Okay. And then another one that I don't like either is your spouse could remarry after your death and then give the money to his kids or her kids, or take it and do God knows what with, right? So that's another bad thing. So again, what would happen to your children if something happened to you? The way that I deal and plan with my clients is that even in a temporary emergency, I'm able to draft documents for you that your kids can go to someone that you want them to. Example, you and your husband or go out to dinner and there's a car accident and your kids are with a babysitter. So the babysitter is waiting for you to come home and they have no idea you haven't come home. What's the first thing a lot of them will do? They will call the police and say, the parents haven't come home. The children then go into police custody and then to foster care until your sister or whoever will come and try to get temporary custody. What I draft for my clients are temporary custody documents, temporary guardianship documents, that if you're leaving them with a sitter or a relative, that in the event of an emergency, it says who they stay with until, you need a permanent guardianship in the case of death, but it's outlined that way. So whoever they're with knows not to call the police right away. They have some written documents. One thing that sometimes keeps me up at night is thinking that, if I didn't have these documents in place, that my son would be with strangers. And that's not something that I would want. Again, just a final slide. If you don't have a plan, the default plan, and the judge will decide for you. If you are not familiar with a permanent guardianship proceeding, it's, the friend or family member has to file a petition. So usually they have to hire a lawyer to file this petition in court because now your children are waiting for someone to take care of them. And this is in the event that both spouses have passed. If there's another spouse still alive, that spouse will, 100% most of the time get custody unless there's some issue, right, that you didn't want. And there's a certain document you can file for that if that's the case. But these permanent guardianship proceedings are rigorous, they're complicated, and they take a lot of time and they cost money, So I really don't recommend something like this. With a simple will, you can nominate guardians for your kids. And then the other question I get, and I'll just answer it now because I think it may be a question. People ask, can I name more than one person? Absolutely. You can name a succession. So person number one, person number two, if person number one can't do it, and so on and so forth. I always recommend naming at least 3. And then the other thing you want to do is if you're naming, for example, you're naming your sister and her husband. However, you have to put in a contingency. If sister and husband get a divorce, who do you want them to go with? Right? Sister or husband, right? You have to make sure to put all those in, just basically outlining everything perfect so that there's no question. Because whenever there's a question, that means money and time, right? And I've seen this before where if both spouses have passed, husband's parents and wife's parents are fighting. And usually they're elderly and it's not a good situation.
Mhm.
And this is just what I said, a little summary of the slide. Nominate guardians, say what happens if they divorce or one passes, and nominate backups. And, quite frankly, this decision here, naming guardians, is one of the main reasons that people hold up for estate planning. Because sometimes the husband and wife do not agree on who should be the guardian of their children. And I urge you to not let that stop you from doing a plan. Just decide together and move forward. Okay, what about the money, right? Money is always a topic of contention. What does this include, right? Your estate. So all these things that I'm listing on these slides comprise your estate, your bank account, checking, I'm not going to read all of these, you can see them here. Any business interests, your retirement assets, your home, if you have any rental property as well. Also, life insurance proceeds are part of your estate. Any cars, for a lot of women, the jewelry is part of their estate as well. And so for all of these items on here, you have to decide where you want it to go when you want it to go and how you want it to go. And by go, I mean pass. Under what circumstances do you want it to pass to people?
And also, Hashi, are these any of these can be excluded from the probate?
Yes, and I'm going to, we'll dive into that a little bit. So when probate includes any assets that you own on the date of your death in your individual name, right? In your individual name that have not passed by contract or beneficiary designation or things like that. Let's just use this example in the top left corner, a bank account. So I'm married. If I die tomorrow, and if I have a bank account only in my name, not with myself and my husband, and that bank account has no, at the bank before they used to, you fill out a green card saying, okay, when I die, it goes to this person. If you don't have a designation for that bank account, that is a probate asset. But if you've already designated it to somebody, and so upon death, it automatically passes by contract, that is not a probate asset. If that bank account is titled with you and your husband or you and somebody else, except tenants in common, your portion is considered probate. But the typical one is husband and wife. If all of your assets are titled husband and wife or designated with beneficiary designations, they're not probate assets. Okay, so there's a proceeding in Florida called summary administration, and you can Google that as well. It's for anyone that owns anything under $75,000. You do a quick proceeding. And so that's a great question, Serena. It leads me to say that, obviously the best thing to do is to not have any probate assets, because probate simply means a transfer of title, right?
Yeah.
When someone dies, they need access to that asset. You can't just go and take it. You have to follow this procedure. And so to get it from person A to person B, we have to go to court.
So it is better to exclude some of them because of the lengthy process involved in the probate.
Lengthy process, and also, people may need that money right away, right?
Yeah.
So you have to make it as easy for them as possible. And then finally, the only downside to this is that even if you have a beneficiary designation, it has to be someone that's an adult. And remember, if you don't have any contingent plan, like how to distribute that, even that adult person will get that whole account in one check. So that person may not be responsible, right? Even if they're an adult. And definitely 100%, please, if anything you remember here from this webinar, never ever put beneficiary designation of minor children as the name while they're minors, because again, they're going to have to open up a guardianship and they will not be able to access that money.
Yeah.
Okay.
That's a good
I've seen it too many times. They put spouse as person A, and then in case they're not there, they put their minor children. Please don't do that. Okay. And this is, by the way, I meant to say this in the beginning. None of this should be construed as legal advice to yourself.
Oh, yeah.
This is just general information. So that's my disclaimer.
Yeah. It's a person to person customizable,
Correct. So, we were just talking briefly about titling, right? How things are titled. And title basically means how your assets are going to pass. There's really 3 ways that you can own property at the time of your death. And by the way, if you're following along in the workbook, this is one of the questions on there. Also, question number 4, I believe. You can own it individually, which we just said, bank account in your own name, even though you're married. Jointly, between husband and wife, mother and daughter, or by contract, like life insurance. And I want to make an important point too. If you have a bank account, right, and you have it designated to somebody, so say you have a bank account and you say, my sister will get it when I die, but then your will says something completely different. Everything that I own in my own name goes to my brother. Which way will it go? They will follow the bank account, the beneficiary designation. So they should match, right? They should really match to not create an issue.
Okay, so both should be matching actually.
They should both be matching because brother can come and say, wait, the will says this. No, that asset is not a probate asset because it's already been designated.
It can be excluded from the probate.
Correct. It can be excluded. Now, if there is no name on there, then the brother it'll pass by the will.
Oh, okay, yeah.
Okay. So, jointly owned assets. So there's some risks, the one benefit is, you avoid probate because when first spouse dies, you don't need to do anything. It's just automatically stays with the other owner, right? The spouse. But
can I interrupt you here?
Yeah, sure.
So there are little bit, this is a very, this subject generally we don't concentrate. So a little bit to go over through three of the, words, these ones like a probate, will, trust, living will. So then we can go over through that one, which can be, divided into these.
Yeah, we're
Is it
going to get to
possible?
that.
Yeah.
Yep. That's a great question too. One thing with jointly owned assets is that when the second spouse dies, if they have left it in their own name, that's a problem too, So with beneficiary designations, which what I said earlier, they will go to them if they're 18 and over, and they go outright, right? If you don't have a plan in place, they'll just get a big check. If you guys can mute, that would be great.
Yeah, everybody please mute except Hashi, please. Thank you.
So option A was no plan. Option B is, having a will. And then option C, which by the way, this one, I like this, it's a McDonald's sign, but it's like a Will's sign. A lot of times if you do it yourself or whatever, go online to find, one of these software companies that will do it for you, they don't really take into account a lot of your own personal factors, right? They may not even ask about children or things like that. So I really recommend, that you don't try to do this yourself. So option A is nothing. Option 1 is to just do a will. And then option 2 is to do what's called a living trust, revocable living trust, right? And so these are two, and this is what Srini was referring to. The will, okay, is better than nothing. You can nominate guardians for your children. One thing with the will you can also do, you can set up trusts in your will if you want. They're called testamentary trusts. But those also have to go through probate. So that's just something to keep in mind. They don't spring up right away. They have to go through probate, that process. And in Florida, probate can take anywhere from 12 to 18 months or longer.
Among these, which one will not go to the probate? So when you name it.
So all of them will go through probate. If you have a trust, Srini, if you have a trust, you still have to have a will. And that will is called a pour over will, right?
Okay.
And that pour over will catches any asset that is not, that is still in your individual name. So if you forgot an account, if you forgot something somewhere, right? Some stock, something, that has to go through probate. But if you plan correctly, there will be nothing that needs to go through probate. Everything has been retitled or designated to your trust. And let me get to that slide. So that's a great question. People think if I have a will, I don't go through probate.
Yeah.
You still have to go through probate, whether you have a will or no will. It just depends on what assets are left that have to be probated. And then it depends if you have no will, it's going to go the way the state says. So I want to make that clear. When I used to do estate administration years ago, and now with some probate, if somebody forgot to retitle an asset, or the example that I like to give is on the day of your death, if you're holding like the winning lottery ticket, you didn't know that you were going to die that day, but that asset is only in your name, that money, and that has to be probated.
Oh, yeah.
Okay. So, if you're not familiar, probate court, you have to appoint a personal representative. In your will, you're allowed to name one. But if you don't have a will, they will appoint one for you. So usually someone comes forward and says, I want to be the personal representative. And all these steps have to go through. The lawyer, number 7, is only needed if your estate is more than $75,000.
Suppose if, whomever you put the probate, if he dies, or at the same time, if both dies, then what happens?
You mean the personal representative?
Yeah, both.
You
Yeah.
name another one. So
So
you can
that's
name
why you want to
successors.
back up 2 to 3 people.
2 to 3 people, exactly.
Okay.
And a lot of another question I get, and you, Srini, you're asking great questions, like they're perfect timing too. The other question I get is, can it be my sister in Canada? Can it be somebody? You can, they have to be a Florida resident, and they don't have to be related to you if they're a Florida resident. If they're not a Florida resident, they have to be by consanguinity, by blood relative. So spouse, nephew, like that, on whoever has passed away. It has to be their blood relative if they're living outside of the state of Florida. Okay. And, honestly, a lot of people don't like probate because it's public. So you can go and look at anybody's will if you want. Now, there's some cases where you have to do a will, maybe people can't afford to do the trust or whatever it may be. And it's okay, but you can make the will and there's not a lot to see in there, especially if you join it with a trust. Okay. So
No.
probate is expensive. And I gave an example here. Usually it's between 1% to 3% of the estate.
Okay.
And I gave a slide here. So this slide, this total estate is 1.8 million. Now, if you see the first line is darker main residence, because in Florida, usually the main residence is homestead property.
Yeah.
And homestead property is exempt from calculating the probate estate because it's exempt from creditors. So this slide can apply to other states where they don't have the exemption, but that's why I put it here in dark. So if it's your homestead home, it's not going to be included in this total probate estate. Okay. But rental property would be, that's not your homestead, right? So you can kind of look at that. And then the next slide shows a percentage. So this would be the fees if you're including this first home. So this includes all the percentage that the court charges, attorney's fees, all of those things there. And another thing to remember is what we said before is all of these, look, life insurance payable to minor, that will have to go through probate because there's no way to transfer the title to a minor, right?
Yeah.
401k also. Okay. So this is somebody throwing money into the fire, right? If you have money to just throw away, you can do what she's doing, right? But no one wants to do that. No one wants to pay all of those probate fees. Okay, so in Florida, usually 12 to 18 months. If there's no fighting, right? That's if there's no fighting. If there's fighting, that's a whole nother nonsense you don't want to have to worry about. And the other thing is assets are frozen. I've actually seen, Srini, people that are set to inherit from their mom or dad, but there's no plan. So they go to seek donations from people because they don't even have money to live from month to month because they were waiting, which is this is not good, to wait for somebody else to die for money, but they have to, especially if there's some kids involved too, So wills are public, and anyone can go down to the courthouse and see. Now, they're not going to see what assets you owned. It doesn't say a Srini owned checking account at Bank of America. It doesn't list that. But it will say who you want it to go to. Okay. All right. But if you have a trust, which we're going to talk about in a second, I'm going to go to that slide here. If you have a trust, the will be what's called a pour-over will, which is what I mentioned earlier. And it will only say, hi, my name is Hashi. I'm no longer here. My personal representative is person X. Everything that I own goes to the Hashi Richards Trust. That's it. They don't know anything else, right? And it's only filed if I have to do a probate. If I never have to do a probate, if I did everything perfect, every asset is already going to the trust, no one will ever even know I have a trust because it's not public record, okay? And 95% of clients will choose revocable living trust. It's basically a will on steroids. You can name beneficiaries for your assets, especially if you, very important if you have minor children, you can name them in your trust. The good thing about this trust is you can change your mind as many times as you want. You can amend it. You can take things away. It's like a basket. So you own this basket the same way you go to the bank account to the bank to take money in and out. You can do the same thing with the trust. Put things in, take things out, everything you can do while you're alive, just like you would with the regular bank account. And you are in charge of your trust while you're alive. And when you become incapacitated and people say, I'm so healthy, nothing will happen to me, more than likely we will be incapacitated at some point, especially when we get older. And at that point, who's going to step into your shoes to pay the electric bill, to pay the mortgage, all of those things? You can name somebody in there to step into your shoes. Usually it's your spouse, right?
Mhm.
That you'll name them to handle your affairs.
So those need to be mentioned in the trust also.
Yes, and everything will be mentioned. My name is Hashi. I am trustee of my trust while I'm alive. Should I become incapacitated, my husband will step into my shoes. He's successor trustee. When both of us pass away, it's going to my son. My son's trustee will be my sister. My sister, if she doesn't want to do it, will be my, sister's husband, whatever, right? When my son passes away, where is it going? All of that can be there.
But
Also,
can you name the other not relative, blood relative or
anyone. And
anyone?
I recommend oftentimes if there is more than one child, or if there's any possibility that there may be disagreements, anything like that, you can nominate a corporate trustee, a bank. If your estate, if your children have special needs or anything like that, if there's substance abuse issues, you can nominate a corporate trustee, which I highly recommend, because guess what? They are completely objective. They have no interest in whether your child gets $100 or $1,000. They're going to follow your direction exactly. And sometimes another great point, Srini, we should do these more often because we're connected on this webinar, that sometimes sister doesn't want the responsibility. So brings up another great point, that whoever you name in these documents, please don't just name them with no conversation.
Yep.
You need to talk to them, especially guardians. Take sister out to lunch or dinner and say, this is a hard topic for me to talk about, but in the event that my son is past, that I die and he's still under 18, I would be honored if you would take care of him. And if you don't want the responsibility, please tell me, because then I can talk to somebody else, but I feel like he would be best with you, right?
Yeah.
And that way they have known. I've seen where they don't know and they get a phone call. Hi, you've been named guardian. There's like, excuse me, I didn't even know that was something. You want them to be prepared in case that happens. So the trust, very simple to set up, sometimes a little process to move the assets into the trust, but you have to be deliberate about it. You have to plan and do it like a job, right? You're going to retitle assets to your trust or beneficiary designate them to the trust. And everything that's in your trust will bypass probate when you pass away.
So anytime, when you put the trust, you can include any property in and out, you can take anytime before you die.
Correct. You can
right?
sell things in there. You can sell stock in there. You can sell a home in there, all of those things, because you're in control.
If you miss anything, then it goes through the probate.
Correct. If it's in your individual name and there's no beneficiary designation, that will have to go through probate if you're interested in that person who wants it is interested in transferring the title. If you go to any state, Srini, and you type in unclaimed property, there's thousands of dollars of assets of people that died or that don't know they have something. So only the probate is really only necessary if somebody wants that, right? Otherwise, they'll just stay in the unclaimed fund for that state. But if you have an interest in gaining access to that property, you have to go through the probate process unless you've done one of these plans.
So it looks like when you compare with the will and the trust is more easy to set it up and operation. Is that one?
So trust is the same way set up wise, as far as, it takes more time to draft. If you are hiring an attorney, there's more planning as far as the questions to ask and things like that. There's a little more to do with the trust, just to make sure you have all these, sub trusts and things that you want. But then once you have it drafted, then it becomes the job of you to make sure that all of your assets are retitled into the trust.
Yeah.
I only know what you've told me. And so when you work with an attorney, the attorney can help you. Usually they will charge, depending on how many assets you have, to help you title them, because it's a process for an attorney to step in and try to help you retitle those assets, right? For property, for homes, right? If you own a home in another state, so we live in Florida, if you own a home, for example, in Georgia, you have to either have a deed from Georgia, deeding it into the trust here, or you can hire a Georgia lawyer to deed that. I cannot, as a Florida lawyer, draft a deed in Georgia, another state, to move that property into your trust. So somebody from that other state will have to do it. Okay, so again, a trust spells out, I'm going to give you guys an example. So this is Bob, right? Bob has $100,000 in his bank account. He wants to leave it to Fred when he dies. Fred is his son. But he wants Fred to be at least 25. He wants him to graduate college, all of those things. He just doesn't want to give him 100,000 right away. A trust would be a great way to do this. It's not public. No one will know that you wanted Fred to be 25 and go to college, and so you can set it up this way in a trust. It's a great way to do it. It's private too. Now, some people that have children, and Srini and I were touching on this earlier, in our community, sometimes this is an issue and no one wants to talk about substance abuse and things like that. But if that is an issue in your family, then this way is a great way to plan. You can say, you know what, my son will be required to go to drug testing or alcohol testing once every 6 weeks. And only then, because otherwise, people may say it's controlling, but really it's protection from themselves. Okay. So this is a great way to set it up. So in a trust, there's 3 roles. The grantor, who's like, I'll use myself as an example. I'm setting it up. I am in control. I'm also the trustee while I'm alive. And then when I'm gone, the beneficiary is the one who gets the assets. So this couple here, Harry and Wendy, they're all 3 while they're alive. They're benefiting from it. They're the grantor and they're also the trustee. They have total control over everything. Okay. So let me go through here. When we went through the title, how to hold title. And then I want to go through one slide. It's like a backpack, like I said. It's, by the way, it's question number 7 in your book. You can put anything you want in the backpack. You can pick out the backpack, like when your child starts school, they want to pick a specific one. There's a million different ones to choose from. Same with your trust. You can customize it to exactly how you want. And anything inside that backpack will be avoiding this probate. Okay, so they show an unfilled backpack and a filled backpack. And then she's putting everything in the bag, just like you would put everything in to your trust. And let me tell you, I've seen cases, Srini, when I was working, when I first graduated from law school, I won't tell you how many years ago, that people would do all these documents, will trust everything, and they never did step B. They never funded the trust. They never transferred anything in, and they had to go through probate. And then everybody saw the trust. So
they don't fill the backpack.
They didn't fill the backpack. The backpack is empty. No books, This trust solves all these problems. There's no time with the trust. Once I die and my husband has died, the successor trustee immediately will be able to distribute to my son the way that I said. And, for him, and for a lot of clients, it may be a lifetime trust where that trust will last his entire lifetime to pay for anything that he wants to have paid for. And then when he passes, it will go to his children. Right. So it's like setting him up and keeping him protected. Okay, so we've already gone over these. A lot of these slides, usually the presentation can be longer, but you guys are getting the idea here about the backpack. And then this is what I was talking about, Srini, this trust. In the pour over will, you're going to name the guardians for your minor children. So in that will, you'll say person X will have my children. If not person X, person Y, so on and so forth. So things that we worry about, kids getting divorced, assets going to strangers, all of these things with, let's look at this example. I put a couple here. 2 children, Harry and Wendy, the couple we saw earlier, they have 2 children, Denise and Sam, and they're leaving behind, or let's say they leave behind $2 million. So Denise will get
Yes.
1 million.
Yeah, estate
Sam,
planning.
can you see, is that you, Srini, or somebody else?
No, somebody else.
Okay.
I know.
Okay. So you're married couple, they both are gone, and left is $2 million. So typically they'll leave 1 million to Denise, 1 million to Sam. And then we get to meet Jason, who is Denise's husband. Jason is not, he doesn't work too much. So she gets the $1 million. And in this case, the way the parents may have set it up is, she gets it outright, because a lot of times parents put in there at 25 years old, my child will get 1/3. At 35, they'll get 1/3. And at 40, they get the remainder. So oftentimes they're already 40 by the time the parents have passed away. So they'll get $1 million check. Instead of leaving it, setting up some trust or anything like that, they give it to them outright. And what does Denise do? She'll put it in the joint bank account with Jason. And then Jason will go and file for divorce 1 year later. And guess what he gets? Half. That's a nightmare, right?
Yep,
Okay,
yep,
so that's
yep.
not what they wanted. Next one, Sam gets a lot of in accidents and things like that. He's not married, but one day, he takes the $1 million, by the way, he puts it also in his checking account, and then he leaves the water in his tub and the whole apartment floods. His neighbor downstairs sues him and says, oh, I see you have $1 million in your bank account, because they can look up your assets, and he loses almost the whole thing with this accident.
Wow.
Terrible, right?
Yeah.
And some people tell me, when I talk to you, it sounds so catastrophic, but these are real life things, and I don't enjoy talking about them, but I have to educate, right? And these things happen. So how do we ensure those things don't happen? Like this, you can make these children's trusts, which is what I was talking about, that I set up for my son and that I do for my clients. It's like a toothpaste tube. And so you push out a little bit at a time, and whatever is pushed out, they can use, but you can't put it back in. Once they take it out, it's gone, right?
Yeah.
So you have to plan. You can plan perfectly. They can squeeze out when they need.
Yeah.
And you can pick your trustee. And by the way, you can also, when your child becomes a certain age, they can be the trustee of their own trust.
Okay.
And you may say, well, Hashi, that's how can they'll just say, I want the whole thing. No. They still have to follow the standard that's set in the document. They can't just take the whole thing. They still have to follow.
Yep.
Okay. All right. So let me just go through this toothpaste example. And one question I always get, estate taxes. Hashi, what about estate taxes? Most people will not have to worry about it. 2023 estates for married couples is more than $25 million that are subject to estate taxes. Okay, individual is about 13 million. That means on the day of your death, if you own 13 million in assets, you'll be subject to federal estate taxes. Okay.
Okay.
So that's really not an issue. And Florida itself does not have a state estate tax. Some states do, like New Jersey, I think New York does. Florida does not. There's only the federal estate tax. So for next steps, if you want to hire an attorney, you can always call an attorney. I work in Florida. You can try to do it yourself. And when should you get started? Yesterday, right? Already should be starting as soon as possible. As far as an investment, how much it costs, you can do it yourself. I think this person here is lighting something and he burned his whole face, right, and his hair. You can try to do it yourself, but honestly, and this is not just an advertisement, please don't try to do a will trust yourself, because it may not go the way that you want. And this is a public service to explain to you, please don't try to do it yourself. There's a lot of times it's cookie cutter, or you don't know how to fund and things like that. My process is a webinar first, which is now, and then we do like a design meeting where we sit down and we go over your family specific plan.
Mhm.
And then the attorney drafts, and then we do what's called a
ये
document
तो
review.
सबको आता ना तेरे को मेरे को
I don't know if you can mute Srini.
So here, please, can you guys mute?
Yeah.
So here, so what? So far, great one.
Srini, you can mute all. Srini, please mute all. That option is there for you. Please mute all
Yeah,
so
yeah,
that you don't ask individually.
yeah. So so far, it's great going. There are questions, we have here
Yes.
also, Hashi.
Sure.
So
Really
one
quick,
more.
Srini, can I just show this one?
Yeah.
Just some options here. You can just do the will.
Yeah.
You can do a will and a trust. And then this one, the third option is if there's many other factors that you need to plan for, and while you're asking the next question, I just want to show people might wonder what things are involved in these documents.
Mhm.
And one thing that the number 14 is important. These are for your own minor children to
Mhm.
have their own power of attorney in healthcare. But go ahead, Srini, you can ask the question.
Yeah, if suppose, if they write here, and there are a lot of non-immigrant, if they go back to India, so what is the, execution for these wills, if they go India?
Yes, so that's a great question. I have a slide here for this. So I'm not licensed to draft wills in India, right? So typically what I recommend is, so a couple points, there's no official USA inheritance tax from gifts from non-USA person to USA citizen or resident. But there is, it's a gift over a certain amount, I think it's 100,000, you have to fill out certain IRS forms. So if you're getting something, inheriting from somebody in India, that's non-USA citizen, there's some forms that you have to fill out. I can't remember the exact number. I think it's 3504, I think. But the income you receive worldwide is subject to tax for US citizen or resident. So you have to be careful if you have, if you're inheriting from people in India or if you have assets in India generating income. So in India, they refer to immovable and movable property. So immovable is real estate, right? If you own property like real estate in India, it's best, and I really advise, 2 wills, because the USA will does not govern India property. USA will governs USA property. So you have to have an Indian will drafted in India by an Indian attorney to govern any immovable property in India. Otherwise, same as here, the Succession Act, which was from 1925, will govern there. The Succession Act in India will govern unless you have a will saying otherwise. And I know there's ancestral provisions and all of those things also. But depending on what state, if you want to email me, I can try to link you with an Indian attorney, because even for my own mom, I'm telling her also to deal with her properties there as well, because me, even though I was born in India, I've been here many, many years. The last thing I want to do is have to deal with the Indian laws there, me not being familiar. So if you have children here that are like me, that have been here many years, or even yourself, please make it as easy as possible for your children, because if you don't have it, the succession laws there will apply. And then, so you're legally allowed to have 2 wills, one here and one in India. Okay. Please save the time and headache. And then also another thing that you can do is whatever city you live in here, in, for example, Atlanta Embassy or wherever, Chicago Embassy, you can call them to find out what the process is, because I believe you can go there and register your will with the embassy. Okay, so if you need help with that, you can send me an email and I can try to link you with an Indian attorney as well.
Sure. So with this, the great discussion. So which one you recommend for the people, to go easy, to set it up, the will or the trust? Because you need to, clearly, then only people can understand. It is a general question for our situations.
Correct. So, and the lawyer answer, Srini, is it depends.
Okay.
It depends. So I cannot give a blanket answer on everybody here needs a will and a trust. But if I were to leave the call now and it disconnected, please, everybody on this call, at least minimum have a will for yourself, have a will for your spouse, designate guardians for your minor children. And if you want to put parameters in place for your children that they can inherit at certain times and rules, and you don't want them to be public, then you definitely need a trust. There's no dollar amount that I can say, okay, if you have more than 1 million, you need a trust. No, it's all these other factors. Do you want it to be public? Do you want to put parameters that are not public? You know, all of those things. But at a bare minimum, please do your will and please have these ancillary documents. And that slide that I was sharing, please have your designation of healthcare surrogate. Please do your durable power of attorney. Please have a living will. You know, there's a famous case in Florida. You can all Google it. Terry Schiavo. Okay, she died when she was it was a 10-year battle, but she was only 25 years old. She's married to her husband. She had a stroke. And she didn't have this living will. A living will is like a document that says, if I were to have a terminal condition, what's going to happen to me? Do you want me to just pull the plug or do I want to stay alive? She didn't have that paper. Her husband, who was only 25, 26, said, you know what? She told me to pull the plug. She told me she wanted to go. Her parents were only, you know, in their 40s, 50s. They said, that's nonsense. I wanted her to stay alive. She told me she wants to stay alive. 10 years, she stayed on this life support like a vegetable until finally they decided to pull. You know, these documents are very important. Those are the ancillary ones. So that at a bare minimum, Srini, will and those documents. If you want all these other things, definitely will and a trust together.
So here is some questions like how we can make aware of spouse, whether, you know, you're doing the will or the trust, you know. So how do you communicate? What is the channels?
So you mean as far as planning for the spouse as well? Is
Yeah.
that what you're asking?
No. If suppose if you do the will or the without, you know, knowing the spouse or somebody she don't know, but you name it spouse in that will or in the trust. So is there something like you know, communication process involved in that one officially?
So if you're not married, you mean, or you're locate a spouse?
Spouse is there.
Yes. So if you're legally married,
yeah,
you know, that spouse is entitled. Florida is very different, and I'm not going to go into all the specifics of Florida law, but if you're legally married and you have minor children, and if you die with no documents, there is a specific way that has to pass. You know, the husband or spouse will get a life estate, the children will get the remainder. That is a nightmare process to have to worry about. So I really urge you to plan. If you're married or if you're asking if you're estranged from the spouse, they're very easy to find. You have to do what's called the air locating service.
Okay.
Okay.
Okay, that's good.
Yes.
So anybody having any more questions? Because, and also, can you give a little bit estimation for the people to understand to do this will or the trust or a living will? Can you give a little bit estimation on that?
Yes. So typically, you know, an attorney is going to charge for the planning, the meeting, the drafting, the review, the signing, all of those things. And so the value has been conveyed on all of these documents. So typically, if you just want a basic will and you know, these ancillary documents, it's going to be for a couple, maybe $2,000 to $3,000 for both. Okay. If you want the will and a trust, that is almost $5,000 for a couple. And then the more advanced planning, the prices will go up. But if you look at it as a value now, rather than having to pay so much money later, it's really, really well worth it to be able to plan properly. So
the basic one, it is going to cost 2,000 and a little bit above.
For a couple, it'll be, depending, it'll be between $2,000 and almost 4,000, depending on exactly what they're looking for. Okay.
Okay.
And I don't like to, Srini, you know, I don't like to
No,
give
just a basic
prices.
idea. Just
Yeah,
basic
basic idea. Yeah. And then if you're planning for yourself, the prices are, you know, if you're not married. And by the way, if there's anybody on the call that has children that just started college that have turned 18 years old, please, for them, they're adults. You know, they may still be our babies. Even when my child turns 18, he will still be my baby. But the day he turns 18, he has to have his own documents. Especially, God forbid, there is an accident in college and you call, they legally should not be giving you any information because they're an adult. So they have to have those documents as well. I
Oh,
don't know if
that's a good question. Good
It's a
answer.
very
That
good
one.
question.
Very good.
And typically I do college planning packages for your kids. They don't need so complicated things at 18, but they do need the durable power of attorney. They do need the healthcare surrogate and living will, you know.
So yeah, I think that's a great knowledge you shared, for this one, where especially our Indian community generally we don't put weight on these and considerations for this estate planning. And one more area is very important is the life insurance. These two areas, our community needs to concentrate on these two things. Actually.
Yeah, and Srini, you know, again, being Indian immigrant myself and being here, I've seen issues from both sides, you know, so I'm well aware. And, you know, do your family a favor. And again, I'm not telling you what to do with your family, but I strongly advise for parents to have open discussions, especially if you have adult children, to make it easy. It's nothing to be embarrassed about. No, we don't need to feel any type of shame. I know traditionally in our cultures, we may not talk about money like that, but it's a gift to give to your family to be able to talk. I know with my own son, I really try to talk to him about these things so that as he gets older, he's knowing, right?
Mm-hmm.
So someone is saying, can we nominate Indian blood relatives? Yes, you can, but you have to think, Pratibha, you have to think about the kids. Are they going to move here, the guardians, or are the kids going to go there? Like, what is the logistics of that, right? You have to have that discussion with those guardians because you don't want to uproot the children. For example, if you're naming a guardian for somebody that lives out of state or out of country, do you want them to move there, or is that person going to move into your home and not uproot the children? So she's saying kids will go there. If that's something that you've planned, then the child will have to move, right? So they're going to leave. And again, we don't know when our death will be, but right now I'm using my son as an example. He's 11. He would be very upset if I have to tell him to go move to another state. His friends are here, his basketball, everything is here, you know? So we're thinking, is that the best interest of the child? And if you have not named guardians, if you don't have a will, that's the standard the judge will look at. Best interest of the children, not you. Best interest for the child. Okay.
And also, one more, because our immigrants, our community, from one state to one state, they move. So now, if I do in Florida, if I move to some other state, okay, mid or west or east, so how we can approach on these ones?
Right. So the laws will govern in the state that you are living in and die in, right? So if you're a Florida resident, you're domiciled here, that is the Florida law will govern. If you move to another state, my 100% advice is you take whatever will you have drafted in Florida and you call the attorney in that new state and show them that will and say, and now if you're planning on being a resident of this new state, for them to either draft you a new will, because inheritance and testate statutes are different from state to state, and also testate if you have a will. If you say, for example, you have a Florida will and you move to Georgia and don't do a new will, Georgia law may govern if you don't have a will, right? It may pass differently than Florida.
Yeah.
Okay. So strongly recommend people call me if they move to the state and they're planning on staying to revise their will or do a new will.
Oh, okay. So for existing will, they have to show it to the attorney over there, and if there are any updates needs to be made, so those need to be made.
Right, because it'll say if you're moving to a new state, I am a Georgia resident, or I'm a New York resident, no longer Florida resident, right? That will is no longer, they're no longer a Florida resident per se.
So that's
Okay.
good. So there is a question, I think, what is the process that in terms of adding or removing assets into the trust?
The
No.
same way, you know,
Same,
you can either add it, you can add it now by retitling your asset, right? So but first you have to create the trust. Once you've created the trust, you can retitle the trust into retitle the asset into the name of the trust, or you can beneficiary designate it, meaning you can leave it in your own name, and then upon your death, it'll go automatically to the trust. And there's a question here, if you move, we have to pay again. If you hire an attorney, you have to pay again to draft a new will. If you do it yourself, then it's free, right? But nothing really is free, because if there's mistakes made, somebody will be paying for it, whether it's you or your beneficiaries.
So it's like there is apart from the attorney fee, is there anything like the state fees are there or anything involved?
That's right. Those are the probate fees, the administration fees, and there's court costs. You can Google, I strongly recommend all of you Google, we're in Florida, Google Florida probate administration fees. There are statutory fees that they recommend that are charged. So you can go and look on there. Just to file, I think, is a few $100s, right?
I have a question, comment.
Yes.
Comment. Coming from India, and I know exactly some of the things that we think are not important. We don't do our own surgery, right? We go to doctor. Same thing, we need skill. So we are not skilled at everything. So we need to, and I am good example to this. I am in the process of doing this. So it's really, really important, to go and get the advice of a person who went to school and have experience.
That's a good point. Yeah, that's a great point. Thank you for that. And I'm glad that you're also doing your own planning as well.
Yeah. And thank you, Hashi, because the recent case, it's so sad to know that our Mukesh Srivatsava, just 3 days back, he passed away. And thank you for helping Anjali, for the will, to do that one. So the last minute they have to do this one actually. But we don't want those kind of situations. It is better to plan ahead, and Hashi is very helpful for our community right now. She is accessible. So how to reach Hashi is here. We put it in the chat also. So it's a great contribution to our community, Hashi, on this important subject. Actually, it is very needed actually.
My pleasure, Srini. And again, if you ever want me to do another one, I'm more than happy to share, because my goal is to make sure that all of us have open communication with our families, and nothing should be embarrassed about. And if you call me, we have these open discussions, so you're able to share with your family, because at the end of the day, when we're gone, the only thing that should matter are memories, and there should be no fighting over this. We want smooth transition, and then our loved ones will live on in peace and not any fighting or anything like that, really. Okay. And you're welcome, Swapna. This was such a pleasure, nice way to spend my Sunday morning with all of you. So thank you so much. And you can follow me on the social media, and maybe I can end up meeting some of you in person, whether you call me or we do an event in person. But thank you so much again for your time.
Thank you so much, Hashi and Madhurima. This is very insightful, and a lot of new things that we learned, especially the living will for 18 plus. My daughter has just turned 18. That was very insightful, and hope to have more sessions like this, and very, very helpful. Thank you so much.
No problem. No problem.
Yeah. Anybody having questions before we close?
There is one question I see Satish is asking about what tactic. Satish, I don't know if you're here in Florida, but if you're planning on moving, send me a message. If you're going to another state, maybe it's personal for you, I can help you find a lawyer there. You know, one thing that's really important too is finding someone that you, people hire people, even myself, you know, whether it's someone coming to fix the bathroom, somebody, you know, house things, someone you know, like, and trust, right? And so I can help you if you are looking to move. It's no problem, you know, to find somebody in another state that I know, like, and trust, that hopefully you will also. And yes, you guys are so welcome. It was such a pleasure. Everyone is saying thank you, and I really appreciate the time.
Yeah, this recording is
Hey, I have one last question. I'm sorry to interrupt. So say, for example, we have properties in India, but we do have a will and a trust here. Is it good that we incorporate them in the will and trust that we did in US, or to have a will in India as well?
The will and trust here will not incorporate those properties. So you
Include.
have to,
Okay.
you have
Okay.
to have somebody. What state is it there?
It's Andhra,
Andhra, yeah.
Telangana, sorry.
Telangana. Okay, so you need to have an Indian attorney there looking at those properties too. So you're passing those properties according to Indian, the way you want it done there, right? So the American will not govern those properties over there. So if you want to
Hashi,
send me an email,
if I may, it's okay. This is Madhurima, the immigration attorney. A lot of you know me. Shrujani, you can reach out to me. We just opened a law firm in Hyderabad, and we could help you. You have my number anyway.
oh
Yeah.
yes,
Thank you,
Madhu, that's right.
Madhurima.
good.
We're
Thank you
both
so
from
much.
the
Thank you.
same, we're both from the, we both, you know, I
Thank you.
speak Telugu, and so Madhu
Yeah,
and I are
చాలా మంది కాల్లో ఉన్న వాళ్ళందరూ తెలుగునే, Hashi.
okay.
No,
But yes,
Anyway,
Madhu
I
has
don't want to talk in Telugu.
we have a lot of people.
offline, mother.
We have a lot of people from the different communities also here. And thank
Yes,
you.
yes, that's
And
why I want to keep it in English, you know.
yeah,
She is a great, great friend of me, and she's like a sister to me, but I can vouch her that she is a great, me ourselves, my family, we did the will and trust with her, and she will follow up like anybody else, like, you know, making sure that you get it. It takes a lot of time and paperwork, but she will make sure that you'll get it until the finalize the documents, you know. I'll definitely tell that. But if you want to reach out anybody in India, please do reach out to my law firm, Paturi Law,
yeah,
which you know that we practice real estate and immigration law here. But if you do need somebody in India, I can help you with that, and we can talk to Hashi about it. But make sure that at least as she is keep telling and refocusing on it, every community member should start thinking about it. Is very important.
Yep.
Madhurima, I'm so
Thank you
glad
so
you said
much.
it because I need it. I
Yeah.
need a
Yes.
lawyer.
Okay.
Sabayama,
Okay.
yes, you can
Yeah.
call Madhu. And then also there's a question here. And Madhu, thank you so much. I didn't even realize you were still on the call. Yes, Madhu has an amazing office there in India. She can help facilitate this other part of the properties and things there. And there's a question, are there sessions in English or any other languages? So this is English for now. Please don't ask me to do one in Telugu. And then Madhu, so Madhu, they're asking for your contact in the chat. Can you post it again? So then
Yeah,
people
I'll put that down. Yeah.
And it is gifted for our community. Madhurima Garu and Hashi both are gifted for us to have this kind of knowledge to share with our community and to make aware our what is our urgent needs to do the things. That's great. And the CFIC is always trying to make aware and educate the community. So what needs to be done as an urgent task? Two things. One is life insurance and the other one is estate planning. These two are very important. And I think next month we are going to take up a very good campaign on to enroll into the life insurance thing, actually, because it's very important. Everybody needs to get the life insurance because of the so many situations now we are going through.
Sweetie, can I add to that? Thank you so much for saying that. That's the number one thing I tell clients, especially with minor children. Do you have life insurance? And if you do, you probably need more than you already have. A lot of you have employer-sponsored life insurance, not enough. please talk to Srini and whoever. You
Sorry
know,
to
about-
interfere. We got
Yes.
this link through some other group. Suppose you guys are planning to do, I heard that you want to start one on insurance. How do we get the link for that? Because
So,
I don't know if we're
you
going
can
to get
join
it.
into the CFIC group, then we can share it with you. No problem.
How to join the group?
Group, can somebody can somebody put that one here, please? Vinay Garu is there?
Srini, I'll reach out to her. I'll give her the link.
Okay, good. Thank you.
And
No
then
problem.
one
No
thing
problem.
just to add,
All right.
Srini, if you have life insurance now, please check your policy and make sure it is not minor children as beneficiaries. You know, do that gift for yourself, okay? And Madhu posted a link for her website in the chat, okay?
And also, can you post one more time for the Hashi also?
Yeah. I'm posting it now. All right. You can send me an email there as well, okay?
Yep.
Thank you so much,
Thank
everybody.
you. Thank you, Hashi.
Okay,
Thank
thank
you.
you.
Thank you so much. Thank you,
You're
Madhurima
welcome.
Garu. Thank you so much.
Thanks,
So,
Madhu.
lot of
Thank-
participants joined
thank-
today. Thank you very much.
Okay, bye-bye.
Thank you,
everybody.
Madhurima Garu. Thank you, Hashi.
You're welcome. You're welcome.
Take care.
Hope it
Bye.
helped. We can definitely keep doing more legal
Thank you.
awareness in the community. Yeah.